Good afternoon, everybody. Thank you for joining us this afternoon. We're very lucky today to have Sean Metcalf from Infantry Base, who is going to be talking to you about the Renters' Rights Bill and the consequences, compliance and control. So without further ado, I'd like to pass over to Sean.
Lovely, thank you. And good afternoon to everybody, and thank you very much indeed for attending. I'm sharing my screen. Unfortunately, it's not allowing me to go full screen, so I'm hoping you can see this, but you'll also get a copy of the video, the recording, and also if you want a copy of the slides, then feel free. You can ask Rachel at the end of the session to be able to get a copy of that. So, bit of context. So I know Renters' Rights Bill, we've been talking about it forever and a day, and it feels like it has been literally years since we started this discussion, but now we're at the tail end. But I think it's right to only say that the letting sector is undergoing major change, as we all know. And what that's going to mean is tighter safety standards, harsher penalties. Local councils are already stepping up enforcement. We're seeing this time and time again. I'm hearing it on the grapevine. And as we move to Royal Assent, which we think is going to be around about the autumn time, getting prepared now is critical. And I know there's a load of webinars going on. There's loads of discussions going on, either between the corporates or very at local level. But I think it's worth to note that despite knowing about it, being prepared and being ready for it, and actually getting on with the work that's needed prior to Royal Assent is where the agents are really going to make sure, certainly from their own client base, that they're prepared and the landlord's prepared and also the tenants are prepared as well. So the idea behind this Power Hour is to give you some practical tools, some strategies, and also reporting workflows to both stay compliant, protect your business, and also avoid any of those costly consequences. So what we're going to cover today is legislative landscape and key changes. We're going to be looking at mastering compliance at every stage and why we need to do that, looking at documentation as legal protection, and also looking at preventing fines and disputes before they happen. So being proactive rather than reactive. Also looking at understanding the financial, legal, reputational risks involved, because sometimes we focus on the detail of the actual act itself or the bill, as opposed to actually what does that actually mean? What are the consequences of me as an agent, me as an inventory provider, me as a part of the letting sector, as a property manager, not dealing with this particular subject. Also going to be looking at tracking and automating and streamlining compliance, and also a strategic action plan. So a 90-day plan of where you can actually start to get things in place and in order. So hopefully that sets out the tone of what we're going to be doing today. If you do have any questions, do feel free to ask them. I know Rachel is going to be looking at those. And if we can't answer during this hour, then we'll collate those and come back to you afterwards. So legislative landscape and key changes at the moment of change. We know that this is coming, but we've known this has been coming for a while. So I thought it would be really useful to actually look at the timeline of the bill. Now, we've obviously gone from Renters Reform to Renters Rights Bill, and I thought it would be quite interesting to put in a table format exactly when all that started. So you can look, we had the first reading of the Renters Reform Bill back in May 2023. So this is probably why it feels so like it's strung out, it's taken ages for us to kind of like get to this point. But it's good to know exactly how things have progressed and where we actually ended up having to stop, mainly because of the fact that we had a change in government. So as you can see on the left-hand side, we never got to Royal Assent. We only got to the point of being in May. We looked at the bill status. We didn't even get through like committee stages and Lord stages. Everything kind of stopped around about the May time, which is quite relevant, bearing in mind we're now already in April going towards May, and that we're seeing a kind of like a similar timeline. So on the right-hand side, you can see the Renters' Rights Bill. So you can see that in 11th September 2024, that was when it's first introduced for the bill reading, and we're gradually moving forward. So we're now in the Lords. We're hoping for the third reading to be June, July, and we've certainly got dates already booked in. It says scheduled there for the 22nd of April, but actually that's actually been agreed and set in stone for the committee stages. And then we're looking at Royal Assent around about the summertime, but it will go into autumn, I think. Months been muted around about October time, but a lot of it is going to be when they can actually physically get it through with everything else that's going on in the world and in Parliament, especially as the Parliament was recalled over the weekend. there could be some knock-on effect to that into what's happening with this particular bill, but we'll have to wait and see. And the commencement date, so when we actually start seeing things actually move and get into actual proper working day kind of changes that we can actually really focus on, something tangible, we're probably looking autumn winter 2025 or early 2026. Now within those dates there are some other preset dates that are already there. So October this year they're looking at the social housing side to actually bring in AWAB's law, and we're going to be looking at damp and mold. So that's already kind of already set in stone, but that doesn't hit the private rental sector until a lot later. But the fact is we still got to be ready for it, because if, like a lot of agents, you're dealing with not only just the private sector, but the social housing sector will have a knock-on effect, because we see tenants going in and coming in from that particular sector. So this will all matter as we go forward. So key changes. So there's quite a few slides here. So I've tried to make them as kind of like as short and sharper as possible. But one of the key ones, as we all know, is the abolition of Section 21 eviction. So landlords will no longer to be able to evict tenants without giving a valid reason. And all evictions must go through Section 8 using legal grounds such as rent arrears or property to sell. So that's just a very generalised context. And the key thing here is landlords and agents will need to have clear records and important evidence to justify those evictions. So it won't be word of mouth. It won't be just, as we do at the moment, no fault, I just want them out. You're going to have to say why that is. There's also one that's maybe not less known. There's anti-avoidance measures and third-party bans. So agent and landlords cannot use third parties to accept pre-tenancy rent. So they can't invite, they can't encourage, or accept payments from a tenant or anyone acting on their behalf. And this is a specific set of the legislation. Section 5 of the TFA 2019 is going to be amended to reflect the anti-bidding principles. So it means now then you won't be able to say, well, you know, I'll pay more than the next person. You won't be able to coerce them. You won't be able to encourage them to accept payments. And if you do, there's going to be a breach. And the breach is a civil penalty if council can prove the rule was broken. So again, any kind of interaction you're having with your tenant and also with your landlord, you've got to make sure that that is all documented and it's very clear as to what has been said, who said what and when, and make sure that there's no encouragement there going on. And this kind of also alludes to the ban on pre-tenancy rent payments. So the clause 10 of the Renters' Rights Bill is adding about rent being paid before a tenancy agreement is signed. This is prohibited under the Tenants' Fees Act, and it means basically landlords and agents must not accept rent in advance before contract is signed and tenancy starts. Now, there is permission in regards to holding a deposit and the tenancy deposit, but anything beyond that is a definite no-no. So whereas before we've had it, so you have like 6 months up front, 12 months upfront payments, that can no longer be allowed to happen. And again, everybody's going to be looking at that to make sure that that doesn't occur. So I say everybody. So we're looking at national trading standards. We're going to be looking at the Ombudsman, and also all of the tenant rights kind of charities like Shelter, like Generation Rent, like Citizens Advice Bureau, all going to be looking to see if anybody breaches this ban. And this is going to have an impact on guarantor products and tenancy risk models. So there's a new clause that's been introduced, clause 14, that blocks the use of rent insurance guarantor products tied to rent in advance. So they're shoring up this particular area just to make sure that, you know, you can't entice, you can't coerce, you can't get a tenant to actually make an upfront payment, and also then blocking any other routes in to be able to do that. And there's another element of this where it says agents can't require tenants to take out insurance in place of affordability. And this could prove a real big problem, because obviously if you can't prove that, or the tenant can't prove that they are able to pay the rent, and they do go down the guarantor route, or you want them to use a guarantor, it could make things a lot more difficult. So this is something definitely to explore. Now, I'm not saying for one moment I'm an expert in this area. I'm totally not. So this is where you need to be speaking to your property mark representatives, talking to your regional executives, looking for the information coming out of property mark, looking at for information coming out from the government, from Ombudsman, so that you understand exactly what this means. But this new clause is something that a lot of people are not necessarily aware of, and certainly I'm not seeing much discussions about. So you've got to make sure that you're aware of everything that will potentially impact how you run your service. And there's also removal defence for unlicensed HMOs. So I didn't know this, and I found this out as part of my research. So Clause 51 removes defence at tenancy agreement barred third-party movings. A lot to say if you haven't got your teeth in right. It means that landlords can no longer claim ignorance if their licensing thresholds are passed by household changes. And that applies to HMOs in additional licensing zones. So this is where, doing your regular inspections, knowing who's in that property, knowing that you've got either a license to get because that is the requirement of that local area, that local authority, or you think it might be, or you've got a new selective licensing scheme coming. You've got to make sure you're ahead and you're aware. So just saying, I didn't know, isn't going to be good enough. So clause 51 is something that you definitely need to have a look at and make sure that you're not going to fall foul of. And then you've got the mandatory national landlord register. So all landlords are going to be required to register with a new national database, and it will include contact details, licensing status, and safety information. And councils will use this register to identify and act against any non-compliant landlords. Now, you could argue, well, if they're not on it, how do you know they're not compliant? But they are going to be using other means and ways of doing it. I mean, one particular way that was actually suggested to me yesterday was whether you're going to use other individuals in the sector. So could it be surveyors? Could surveyors who are going in to do valuations or revaluations based on the factors of buy to let, could that be that they'll end up putting some kind of question on the surveying form on that valuation to say, is this property going to be for multi-use under HMO rules? If it's a yes, how does that get passed? Well, that could get past the council, that could get passed back to the mortgage company. The mortgage company could then potentially have to legally to inform the register and then go from there. So there's going to be different options to be able to capture this information, but the key thing is they are going to be looking for it, and they're going to be looking for different ways of making sure that anybody that does try and kind of fly under the radar, for want of a better phrase, is going to be captured. So they're going to be very much acutely aware that there's going to be landlords trying to semi-navigate this particular rule for registration. So you've got to make sure, again, you're very much upfront on board and making sure that you're letting everybody know that needs to know. And then you've got your ombudsman scheme. So they've got to join an independent redress scheme. Tenants will be able to raise complaints and seek dispute resolution outside of the court system. So it won't mean that just because the ombudsman says, well, this is what's going to happen, this is my recommendation, it won't necessarily stop the tenant from doing that. But the idea is to try and get it dealt with very much earlier on in the course of the tenancy, or when things have started to go wrong, rather than go straight to either to the court system or anything in regards to, you've still got your deposits, but certainly anything worse than that, anything that might actually incur more cost, more time, more legal expertise. And obviously with the court system being as it is at the moment, which we know isn't really fit for purpose, that could then make things go a lot slower and then cause issues in regards to getting the property back, or actually even dealing with the issue. And it says there, the Ombudsman will have powers to investigate complaints and order compensation. Now, in regards to what that compensation will look like, what the multiples will be, whether there's going to be a set rate or it's going to be done on every individual case or case-by-case basis, it's not clear. Then we've got the tenant's right to request a pet. So tenants will have a legal right to request a permission to keep a pet, and you can only refuse as a landlord with a valid reason, and you've got to respond within a set time frame. So that in itself could cause problems in regards to whether the property is suitable, whether it's, you're going to put a Great Dane in a single room on the 17th floor that's only a studio, that's only really fit for purpose for one person, or whether it's actually going to be reasonable, but the landlord just doesn't want it because they worry about the headache of damage and issue and cost, etc. So certainly with the right to request a pet is going to have to be written down, it's going to have to be captured, it's going to have a relevant reason, and also all the evidence to back that. Landlords can require a pet insurance, but they can't require a high deposit. Now that is something that's come up, I think, in recent kind of conversations, certainly online, about an MP who's actually got a secondary home. She has a pet, has a dog, a cockapoo, I believe, called Bella, and that animal is there in the property, but landlords charged additional kind of insurance, additional rent. I think it was about to the tune of about £900. That won't be able to happen. The insurance side of it, yes, but certainly not the higher deposit. Now, this isn't new. This is something that was mooted last year when we're looking at it from a tenant's rights bill. But the fact is it's a lot closer now to becoming part parcel of the Renters Reform Bill. Therefore, landlords and agents, and so yourselves, and also inventory suppliers as well, will need to make sure that you've got things in place in order to be able to capture that information and also monitor the quality and safety and also condition of the property. There's going to be a new rule in regards to rent in advance restrictions. So rent in advance bans will apply to all new tenancies, as we discussed earlier. So you're going to have no more than 3 to 6 months rent up front as a letting condition, aims to remove financial barriers for low income tenants, and also aims to make sure that, certainly from a referencing point of view, that doesn't bar anybody because they don't have rent in advance to pay, that it will bar them from actually be able to apply for the property. So agent landlords must revise referencing and onboarding processes, because any breaches could trigger ombudsman complaints or enforcement action. So the rent in advance restrictions have definitely got to again be looked at. They think they're still going to be in the form they are in at the moment with the Lords, but I know the likes of NRLA and also Property Mark are still trying to get to talk to the government to lessen those restrictions, because it does come with a problem. Some people pay in advance because it's financially easier. They've built up the amount to be able to do that, or maybe that they know that they're not going to fit a particular criteria in regards to renting that particular property. Maybe they've got CCJ. So in a way, paying in advance has actually helped them be able to get that property, whereas they're now going forward, they won't be able to do that. So that could actually put them as a bit an unfair in unfair circumstances, as opposed to potentially help them and giving them an advantage of basically getting a property that they will hopefully look after as time goes by. We've also got the introduction of a new housing standard. So a decent home standard is again something that was mooted last year, again put on the back burner, but this is going to be applying to the private rented sector for the first time. So social housing sector has a housing standard. And we've also had fitness for human habitation. So it's not like we don't have a standard, but it's going to put it into a better form. We're going to be looking at HHSRS in a more detailed way, but they're also looking at revising HHSRS. So at the moment you've got 29 risks, and they'll be looking to consolidate that down to 21 risks, and then give a better way of actually identifying where the risks are and working with the actual what would be the word for it I'm looking for? So the actual kind of calculation that sits behind the HHSRS, whereas at the moment it sits very much with councils, with the environmental health officers, but the idea is to not necessarily dumb it down, because obviously that comes across as rude, but certainly make it more accessible to landlords, to other bodies, to be able to assess that property. But this will actually set a minimum standards for property condition, safety and facilities that every property that's rented out will be measured against. And local councils will have greater powers to inspect and enforce improvements. So again, we're going back to what we were saying very early on. Councils are already gearing up to have this ability to be able to go into property and make sure that that rental property is of a standard fit for human habitation. There's also going to be extension of rent repayment orders. Now, I'm sure we all know about that, but just in case you don't. So at the moment, tenants can claim 12 months of rent, and coming with the new Renters Rights Bill, it will be up to 24 months in serious cases such as letting an unlicensed property, failing to carry out repairs, or unlawful eviction or harassment. So I should have actually given you a different sheet there actually, which I'll come to it in a little while as to what that actually looks from a cost point of view. I'll give you a bit of a case study. But if you think about it, if you look at your general rent at the moment, if it's like say £1,000 a month, so whereas you're looking at 12,000 potentially rent repayment order, now you could be looking double that amount, up to £24,000. So it's a significant change, and obviously higher the rent, the higher the multiple. And then we've got replacement of fixed term tenancies. So all new tenancies will be rolling periodic tenancies with no fixed term. So it won't be 6 months, it won't be 12 months, they will be rolling. So a tenant's basically leave with 2 months notice at any time. So some would say that's great, gives you flexibility, but then it could also create more voids. And also if you're moving tenants in and out on that kind of regular basis, there's a lot of paperwork, a lot of admin, a lot of things to be able to deal with in regards to making sure that that particular tenant has a right to rent in the UK, that they've got the right amount of guarantees or money to be able to pay for the rent, so they can reach the affordability threshold that you've set or has been set by the landlord. So it's going to be problematic from an admin point of view. So landlords are going to have to be very, very careful, and so are agents, in regards to but first of all, who is going to rent that property, whether they're likely to be long or short term, and also then apply any kind of like construction around that in regards to your processes, and also make sure again that landlords can only end those tenancies under specific legal grounds. So it's going to kind of potentially cause a bit of a bottleneck. It's going to potentially cause an issue if we've got tenants moving around all this time every 2 months. One thing to bear in mind is Scotland have gone through this, and speaking on one of the recent Our Property Mark forums, where we were talking to representatives from Property Mark, the regional execs across a country, and one of the regional execs from the Scottish area has actually said, well, they've had this in place for quite a while now, and they don't really see this happening all that often. Now, it doesn't mean it won't, and it doesn't mean you shouldn't plan for it, but certainly in their experience, they're not seeing that kind of turnover that they would necessarily expect or people are worried about. But it doesn't mean you shouldn't plan. So it's something, again, to think about and say, okay, well, what does that mean for me, my business, how I manage my services, and what do I need to plan for? There's also going to be greater enforcement powers for local authorities. The councils will be able to inspect properties more frequently. They'll be able to issue larger fines and penalties, and that could be up to £40,000. They'll also be able to revoke landlord registration for serious breaches. So with all of that, there becomes a lot of worry. So again, a lot of processes have got to be in place. But one of the issues, as I've noted and I've been talking about for quite some time, is will the funding be provided to support enforcement activity? Where are those boots on the ground going to come from? Who's going to be doing that? Because we already know that councils are very much strapped for cash and personnel. And we only have to look what's going off up north. We've got Birmingham with issues around pay. We know that some councils are actually, either if they're not already in the red, they're very much going towards the red. So how are they going to apply all this enforcement? And the other issue you could also argue is, will enforcement be applied in order to generate monies? £40,000 penalty, it only will take a few of those penalties to be issued to effectively, create a bit of a GP fund for councils. I'm not saying they will, but you can understand that it could be a possibility. So again, you've got to look at, well, how can I make sure that my properties are inspected frequently so that I don't need a council led environmental health officer or someone else come into the property and potentially look to issue these fines. There's also an encouragement of digital compliance tools. Now, this isn't legislated in the Renters Rights Bill, but they are supporting a shift more towards digital record keeping and evidence submission. And when you think about it, it kind of makes sense because of the volume that they're going to be dealing with. And if we did have all of our tenancies literally go over into that, well, we will have them go over to the 2 month process, beg your pardon. But one thing is, if we had the movement every 2 months, the amount of evidence, the amount of record keeping that is required to manage all of that is going to be exponential. So making those digital is going to make a huge amount of sense. So these will likely include automated inspections, your audit trails, and your compliance tracking systems. So you've now got to be starting to look at your tech. Well, what do I have? What do I need? Where's the missing parts? And how quickly will I be able to embed and get all my staff trained up to be able to deliver on this? And there's also some areas yet still to be confirmed. So you've got midterm property inspections. Will they become a legal requirement? Will the Decent Home Standard include things like energy efficiency ratings, which has been mooted before? And also, as we said, digital reports or property data, do they need to be submitted to a central system? So these are kind of being talked about, but I'm not necessarily see them in the current legislation. It doesn't mean necessarily that they won't be going forward. And when you think about it, they do make sense if they're going to digitise the whole process. So mastering compliance at every stage of a tenancy. So in order to do this, you've got to look at the life cycle and what that compliance looks like. So you're going to be looking at things like pre-tenancy, your risk assessments, your fitness for human habitation, your Legionella risk assessments, your HHSRS. You're going to be looking at your safety checks, your EPC, your gas safety, your EICR. And also your condition reports, is that property fit for habitation? And certainly when you're looking at it from a social housing point of view, they're already doing stock condition surveys to see what they've got on their portfolios and whether they're actually fit for use, or whether they've got to have maintenance or any major work done before they can be put into the tenancy pipeline. So all of this has got to be managed. And then you've got your mid-tenancies, you've got your proactive inspections, your maintenance logs, and your tenant interactions. So if you're doing live inspections, or you're doing scheduled maintenance or emergency reactive maintenance, all of that is part of the compliance life cycle. And then you've got your end of tenancy, your digital inventories and checkouts, your deposit documentation, and your condition comparisons, which most would look at it from a checkout report point of view. So there's a lot of information you're going to have to gather, bring together, look at, certainly take apart and understand what needs to be doing or be done, who by and when certainly then the property is going to be going back onto the market. The key thing for me here is regulators won't accept a single end of tenancy snapshot. So it's no good not doing the inventory and the risk assessments and everything before the tenancy tenancy starts, because when they get to leave, then a single snapshot, just a checkout report, when you've got none of that information at the beginning, is not going to be helpful. You're going to need consistent, detailed, time-set records at every single stage. And that's not just at the reporting stage, it's all things like when you're doing your comparables for if you're looking to raise the rent every single year. So if you're going to issue a Section 13 and actually raise that rent, you're going to have to say, okay, well, how do I know that that's a reasonable rent? Then you're going to have to do comparables. You're going to have to show those comparables, and then potentially that might be taken to the first tier tribunal for the housing, or it actually might even go to the Ombudsman if the tenant doesn't agree. So now you've got a huge amount of data that you've got to capture, you've got to investigate, and then you've got to action and work on. So it means then you're going to really have to start thinking about it now, as opposed to when this rights bill comes into force. And documentation itself often seems as just like saying it's all about admin, and obviously it is, but it's also about legal protection. And your reports are definitely your defence. So you've got to look at the structure of your report. Does it have everything in there that you need should you need to explain yourself, showcase to the Ombudsman, showcase to the council, showcase to the courts that that property was fit when you handed it over, or you were aware of some issues but you had them scheduled in, and that you're managing the property correctly. But you only know that if you've actually captured that information in the correct form. So your report structure is going to be vitally important, as are your digital audit trails. You've got to be able to see when things were interacted with, i.e. when the tenant got the report, when the landlord got the report, when you're scheduling the maintenance, when it went off to the deposit scheme. It could have gone through an integration as we have with the depository. So all of that has got to be tracked, and all of that is effectively evidence should you go to a court of law. And don't forget, with ombudsman and with a court, ombudsman will do it on the basis of probability. Is it likely that this happened? Whereas a court will look at it based on fact. So the more information you have that is fact-based, that you can prove the provenance of it, will stand you in greater stead should you end up having to, go to ombudsman, the tier tribunal, or equally the court itself. So if you aim it at the courts, everybody else underneath will be protected. And enforcement bodies are going to be looking for clarity. Can they understand what the report is saying? Is it clear, concise? Is there consistency in it? Are you doing the same thing each and every time? So your report structure is very easy to understand, but it's also being done the same way. So when it comes to checkout, the inventory and checkout, you can easily be looked at and can be compared, and there's no inconsistencies there. But also they're going to be looking for neutrality. Are you saying this or saying there's an issue because you're the agent, because the landlord told you so, or because it's an actual issue that's maybe been highlighted by a third party? And that could be the inventory clerk, that could be even, to be honest with you, it could be another body that you're dealing with, like your EICR engineers, your gas safety engineers. So it really is important, certainly from my point of view, to make sure all of this is structured, all of this is captured correctly, and also you make sure that, certainly from your point of view, every T is crossed, every I is certainly pinpointed. And then you've got your reports as your defence. Again, what we were saying just a second ago, they can make or break or dispute, but too many, in my experience, agents look at them as a throwaway thing. It's just something we've got to do. It's admin heavy. It's not particularly helpful. In my view, it's extremely helpful, because if you have that, you don't have to guess. You don't have to look back in your records and go, did I do that? Was I on time? If you've got it all marked out, if you've got it all clearly set out as a strategy, as a focus for how that tenancy life cycle is going to be managed, then it's going to act in your defence. So treat them as legal assets. Don't treat them as, just like I said, pen and paper thing that I've just got to do and it's boring and I don't really want to do it and I'll just do the bare minimum. Look at it from a point of view, would this save me in a court of law if the tenant basically disputed it? And if you're not sure, then the likelihood is it's not going to stand up to scrutiny. So you need to make sure that happens. So in order to be able to do that, you've got to prevent your fines and disputes before they even happen. So you've got to be proactive over reactive. So schedule your inspections ahead of the tenancy issues. Now, you should know if you're going to have any issues right at the beginning, before you get even the property on the pipeline, because you would have done your HHSRS, you would have done your fitness for human habitation, you would have done all the required legal documents, your EICR, your gas safety, your Legionella risk assessments, you would have done your right to rent, you would have done your how to rent. All of those processes would all be there, and your inspections will be part of that, so that when you've done your inventory, you're already aware of anything that's going on. But if you've done the HHSRS, you would have already been told if there's a deficiency, if there's an issue that might then occur during the tenancy or actually needs to be done like now. So that's where you're being proactive over reactive, and that certainly where it comes to AWEB's law with identifying damp and mold and structure and safety hazards early will pay dividends in the long run, because you won't then having to deal with it while a tenant is in the property, which is going to be harder, probably more costly in as much as you're trying to move them out or actually work around them, but also from the complaints point of view. If they're complaining, then you've already lost the argument, because the issue is already there. They can see the issue. So you need to get ahead of the game in that regard. And the other thing also, track communications and rectify them before the problems escalate, because too often I see in my own personal experience, being an inventory provider for over 10 years, is that a lot of stuff that I see in properties that actually have been pre-existing for a certain amount of time. Some of it not as obvious, but other things very obvious. So if you haven't dealt with them in, say, the previous tenancy or previous 3 or 4 tenancies, then certainly from ombudsman point of view, from the council point of view, they're going to say, well, you should have known this, it's all within your paperwork, or it's been identified by tenant A and B and C all the way through the last few tenancies, and yet you failed to do anything about it. But if you're not tracking your communications and you're not telling the right and relevant departments, they're not going to know, you're not going to know, you're not going to deal with it, and then you've got an escalation, and then by the time you've got to that point, then you've probably got a major complaint on your hands, which is going to be a lot harder to deal with. And as I'm saying here, most enforcement starts with a complaint. 9 times out of 10, you'll know about it, but it could be a major complaint, it could be a small complaint, it could be an observation that maybe has been made during either pre-inspection by the inventory clerk, excuse me, at inventory point or check-in point, or maybe within the first couple of months of the actual tenancy itself. But if you're not dealing with it and you're not communicating and you're actually putting things into action, say, right, I need to get this done, I'm going to hand that over to the property manager, they're going to hand it over as a works order, etc., then of course then things are just going to escalate. So, you know, staying ahead of the issues by solving them before they escalate is going to be more cost effective, less admin time, and certainly better reactions from your tenants and from your landlords in regards to reviews and just generally how they've found your service. So you've got to understand the risks of not doing all this and what that impact means. So you've got your financial risks, you've got your rent repayment orders, you've got your fines, and also your tribunal costs. A lot of time we talk about tribunals and going, you know, to the council, etc., and then they taking, you know, that or escalating that issue. All of that costs, and that cost goes somewhere. And if it goes to court, the likelihood is you'll get awarded those costs. And if the council will take you to court, then you've not only got the council's costs, but you've also got the costs from the court itself as well as. And then you've got your reputational. And again, this often gets left to the wayside. It doesn't get thought about. If you are going to the ombudsman time and time and time again, the ombudsman is going to be seeing a pattern. If you've got a list of complaints that gets bigger and bigger, and your Trustpilot and your Google reviews are getting worse and worse, your stars are going down from 5 down to 1 or down to 2, and all you can see is complaint after complaint after complaint, all that affects your reputation. Now, sometimes people will complain just because they can, and there's nothing stopping them. And to be honest with you, once they do complain, in a way, they're waiting for you to reply, and you've got to kind of like justify it. But the fact is, if you've got that number of people complaining, then there's something wrong there, and that will impact you on how you're seen on social media point of view, but also how landlords coming to you, possibly by social media, will look at you. So, excuse me, I'm just going to grab a quick drink. So from that point of view, you could end up losing clients. And at the end of the day, if you don't have those clients, if you don't have those landlords, you're not going to attract tenants, therefore you're not going to have a service. And then you've got the legal side, like failure to evidence is effectively, you're kind of like shooting yourself in the foot. You're tying not only one hand behind your back, you're tying two. Because if you don't evidence what you're doing, you don't evidence that you're being reasonable, that you are conducting your services in a professional manage as required by Property Mark under the codes of your conduct, and obviously the various other bodies that you have assigned to, then of course then you can be called to account for those. And if you're not evidencing everything you do, then how can you then defend yourself? How can you actually stand up in a court of law or in front of the ombudsman and say, no, that's not the case because of this, this and this? They're going to ask, well, to prove it. So you need that ability to be able to prove that, and you can't do that if you haven't evidenced from literally day dot. And then of course you've got your operational risk. You've got increased admin, which, you know, yes, you could use AI to do a lot of it, but there's still a cost there. There's still the human cost. You're still a kind of person-centric kind of service, whether you're a landlord, whether you're an agent, or whether you're an inventory provider. And all of these admin processes require oversight, tweaking. You know, not all of them are exactly as they should be, and sometimes you need to like bring them up to date, especially with the Renters' Rights Bill, where, you know, certain admin processes will need to be managed more effectively. And of course then if they're not being managed, then they'll become broken, and then that has a spiraling effect. So all of a sudden, you know, you've got a lot more risks that you're having to manage just because maybe you didn't deal with a certain situation right at the beginning of when you were first made aware of those issues. And as we said beforehand, there's a lot at stake here. So you've got unlimited fines, you've got your rent repayment orders, so you've got your breaches up to 40,000 rent repayment orders up to 24 months rent. You've also got costs around evictions, because they're not done for free, all of that costs. You've got tenant-led claims, so you could have additional claims over and above these. You've got issues around staff overload. If staff are having to deal with complaint after complaint, it's wearing, it's difficult emotionally and then physically, and that can have a real bad impact on your service if you're losing staff because maybe they just can't cope, or they don't feel supported, or they feel the processes are not supporting them. And that also creates bottlenecks. So of course then you're going to end up with almost like a point where you literally stop still, because you can't go anywhere, because literally the process is just not fit for purpose. And then, as I mentioned earlier on, you've got your negative reviews and you've got your ombudsman rulings. And we already know that they are put out into the ether. They're put on the major portals like Property Industry Eye, like Landlord Today, etc., where they say about who's been to the ombudsman, what's happened, and they're going to be doing this more and more and more. So it's going to be a name and shame kind of culture, whether we like it or not. So of course we don't want to get there. We want to be having these kind of conversations off book, getting them done before they even reach that type of level. And this is the kind of stat I was looking for earlier on when we were talking about rent repayment orders. So if you look at the average rent, say 1,284, you're looking at a potential rent repayment order over 30,000. And you've got 2.82 million landlords in England, and 94% of those are private individuals. And with 23,000 estate agency businesses operating in the UK, you only have to do the maths to work out. So rent repayment orders could be a huge liability, not just individually, but also for the sector itself. And a real good indication of that is this recent case study. So as you can see here, in March 2025, tenants from 2 buildings in Hackney were awarded £263,555.68 in rent repayments after a tribunal found the landlord had failed to license HMOs and meet safety standards. So to break that down, as you can see here, so that's 46 residents from 15 different flats across the Olympic House and Simpson House, and they were awarded that combined total of over 263,000. But if you think about it, if you've got 46 residents in 15 different flats, could you imagine then again if you've got all of those rentals? So you've got about 4 to 5 million properties currently being rented at the moment. So again, I'm not saying every single one of them will go for a rent repayment order, but now it's going to be much easier. So of course then they're going to be looking for that if you've got people who are disgruntled for whatever reason, and it could be legitimate and it could not be legitimate. But this shows you that the appetite, certainly in the tribunals and certainly in the courts, is to make sure that tenants' rights are upheld, and that will mean higher rent repayment orders being, I think, awarded. So you're going to need to track, automate and streamline everything, all of your compliance. So digital workflows for inspections, template-led reporting, having compliance dashboards, auto reminders for action so you don't miss it, and making sure your data security is there, so you're GDPR compliant. So as soon as you've finished your checkout, if you no longer need those tenant details for legitimate reasons, then they need to be deleted. If you've got inspections, then you've got to make sure that they flow from one to the other, and that any inspections you're required to do, i.e. via the insurance document, the guarantor document, depending if that's something that is being used to manage the tenancy, or also your internal process, all of that needs to be recorded. And all of this needs templates, all of this needs a structure. Now, templates themselves are easy enough. You can do them on paper, but that's very labor intensive, or you can do them within, say, the Inventory Base app. Now, I'm not here to sell you Inventory Base, I'm here to help you learn. So whatever system you use, make sure that the template is consistent, make sure that it's very clearly defined and the structure is there, and that you know and understand that particular workflow and information flow. And as I'm saying here, you don't need to do more admin. You've got the tools, you just need better systems. You've got to look at your tech stack. You've got to look at what it is that you're utilising as it stands at the moment to be able to say, okay, Do I need to change what I'm using, or do I just need to make it work better, or do we as suppliers need to work better? You've also got some untapped but also crucial options as well in order to manage all this, which is AI. AI, some people roll their eyes, and I'm sure there's a few people that might be doing that quite right now, but it's a useful tool, but it's only a tool. It can never be relied on because it only knows what we feed it as an industry, as individuals, but it has some good ideas in regards to flagging safety hazards and making sure that your workflows work efficiently as possible. Also, property data standardization, making sure you're mapping every single property using the same parameters every single time. And that way, then you can really see what your portfolio is doing, how it's being managed, and also identify where there's issues. And then you've got protection from privacy and data protection implications. You've got to make sure that you understand GDPR. It's been around for a long, long time, but I do wonder, when was the last time you refreshed your memory on that? When did you last look at whether you had a legitimate reason for having that information? Whether from a corporate point of view, you should have all those in place, but it doesn't mean you shouldn't review them. If you're a sole provider, then of course then the onus is on you to make sure that you've got everything in place to be able to manage that. So you can look to the ICO to get that information, that guidance, and take some of their tests that they've got on their website to make sure that you're compliant, but also make sure that every single year you're constantly reviewing that. There is some overlooked compliance risks as well, so gaps you might be missing. So again, we'll talk about GDPR, about local licensing failures, whether you know whether there's licensing coming up in your area, it's been muted, or selective licenses come in, and also so discriminatory ad policies like no DSS. We're still seeing it. I'm still seeing it under the Renters' Rights Bill. That's not going to be allowed. So you've still got to make sure that from a compliance point of view, looking at every single gap so that you don't fall foul of that. You don't fall through the cracks, and don't fail to follow up on mid-tenancy risks. So if you are highlighting a risk within the mid-tenancy of the interim inspection, whether that's in person or you've done a live inspection or it's been tenant-led, that you're following these up, because these are compliance gaps that should you not protect the data around GDPR, should you not keep up to speed with licensing, and you are still advertising that you don't accept children, you don't accept pets, you don't accept DSS tenants, then you are effectively breaching those compliance. So you've got to make sure that you deal with that and deal with it properly. So what do you do next? So for me, I'd say it's simple, because when you think about it, all of this is admin, this is all workflow. So as long as you're ahead of the game and making sure you're looking at things in the right way, but also within time, rather than waiting for everything to be given royal assent and to be given a date as to when it comes in, because even when it comes in, we don't know if it's going to be coming in like as of this date and that's it, or whether it's going to be brought in gradually, or in a bit like they're doing with from HHS point of views, are you looking at AWEB's law in October for damp and mould, and then bringing in the other risks throughout 26? We don't know. So to get ready now makes a huge amount of sense, which means also you can then look at what admin you need, what resources you need, what tech you need, and also what does that cost and what does that look like, and what do you need to change to be able to manage that. So my advice is for a 90-day plan where you've got weeks 1 to 4, you're looking at auditing, standardizing and aligning all your processes. So look at your tenancy documents, your pre-tenancy notices, your terms, your Section 8 procedures. What do they look like? How are you going to manage them? And more importantly, who's going to manage them? And are they upskilled? Do they know what they need to do? Do they understand the law? Obviously, mapping out current eviction. Sorry, I didn't mean to say conviction. Map out current eviction processes and confirm they align with the future Section 8 only requirements. Because there's no point in just running as business as usual now and then trying to change them literally on the day that they do to change, because those kind of processes will take time to embed. And then you've got your onboarding process to ensure no rent is accepted before a contract is signed. So you've got to make sure that everybody's up to speed within your company, within your service, whether you're a sole provider, whether you're a larger company, whether you're a portfolio landlord that manages yourself, or even you're an inventory provider who's helping your clients to manage these kind of policies. So you need to make sure that you're all aware. And begin staff training on Renters' Rights Bill now, especially around ombudsman and housing standards, because there's a lot to learn. I personally have recently done training on HHSRS. I'm now a qualified practitioner. I've done it so I can understand what does that mean, what is the impact, where the risks are, how it's managed, how the environmental health officers are looking at it, and then how I can then help manage that from a information training point of view, and how I can help yourselves as Property Mark members, but also the wider community in regards to landlords and agents who maybe not part of a Property Mark family that don't necessarily have that information, so we can help guide them. So, I've done that because I know it's going to be important going forward. So you need to look at what training your staff needs, because if everybody tries to train at the same time, you're going to end up with a bottleneck. And then from an inventory provider's point of view, look at your inventory and checkout templates, both for clarity and, as we said earlier on, neutrality. Make sure they're consistent, make sure they've got everything in that they need, and implement pre-tenancy safety checks per Decent Home Standard. Now, we don't know what that will look like as it stands at the moment, but pretty much it's going to be relying on HHSRS, so that we do know what it looks like, so we can get on board and get looking at that now. And also ensure inspections are time-stamped, photo supported and signed off as needed. So whereas beforehand we very much relied on the fact, well, if a tenant doesn't sign it, therefore, well, it doesn't really matter because they accept by default. I think there will come a time where that won't be accepted, and certainly with inventory base, you've got the ability to be able to ask the tenant to sign and also to remind them as well. So you give them every opportunity to look at that report, comment on that report, and also sign that report off. And you've also got to establish a consistent format for midterm inspections. How often, what do they include, what they don't include, how you're going to capture that information, and how you're going to push that forward, especially if you've got insurance companies with policies who require you to do regular inspections, because if you don't and there's a problem at the property, then they are going to be relying on that information to either say yes, go ahead and deal with that, or actually no, you're not covered because you didn't carry out those inspections. And that obviously includes repair logs and tenant communication. So everything is about making sure that if a problem is communicated, that the tenant is made aware, that you are aware, you're dealing with it, you're creating the right work orders, the maintenance being done, and you're doing the follow-up afterwards. And the tenant is kept informed at every single stage of that particular journey. And then week 5 to 8, you've got introduce structure and improve evidence quality. So from letting agents' point of view, ensure or improve compliance around login tools, so your digital dashboards, your CRMs, audit trails. Make sure you know how it works, what isn't working, and get that working, or look at what else you can introduce into your tech stack to be able to do that. Segment your portfolio by property risk. Look at your HMOs, your EPC ratings, maintenance history, so you know where to concentrate your efforts on, concentrate your resources, but also make sure you're keeping on top of everything. And then create a register of your high-risk properties, so those that need license renewals or got poor EPC. So again, you can target those and they don't get missed, because ignorance is not going to be accepted. As we said in the earlier slide, the rules will be that it doesn't matter whether you say, I wasn't aware, I didn't know. The onus is on you to know and to be aware. And also make sure you contact landlords, which I know a lot of agents are already doing, with a summary of upcoming legal changes and what action they need to take. And that should be property specific or portfolio specific. So if you've got a landlord with 3 or 4 properties and at least 2 of them have got an EPC failing or EICR that's due up for renewal, especially because we're in that time frame now for the 5-year EICR time frame, then make sure that they are booked in and that everything is done and done on time. And from an inventory provider's point of view, you've got offer mid-term tenancy inspection services to agents or landlords, not currently using them because it said they're going to be vital for that evidence chain. Start intending engagement logs to reports, and make sure that they've got the ability to be able to communicate on repairs through the information you give in the tenant and commenting column, but also looking about pets and access and what you need to know to be able to carry out those reports. Make sure you've got your policy on photo evidence, how many images you need. So it should never be a top amount, i.e. you can only take 100, but it should be a minimum. Do you need a minimum of 2 per issue, 2 per room? How are you going to capture that, what the metadata is going to look like, and how they're stored? So on inventory base, are automatically stored on your dashboard. And if the client, so from an agent point of view, you're invited into that as a client of the provider, you can then see all of your reports at any given time and take that information off as and when you need it. And the key thing also, check that all your reports comply with GDPR and are stored securely. I often see tenant details, i.e. forwarding addresses, going into checkout reports, but once that tenant is checked out, then effectively their details should be forgotten because you no longer need them. But if it's already in that particular report and physically in the report as outside the report, it means then certainly from our point of view, you can't, I just got given a drink, thank you. You can't keep that legitimately, you don't have legitimate interest. So make sure you look at all of your reports and how you manage them. And then 9 to 12 weeks, you've got operationalise, communicate and finalise. So from letting agents' point of view, implement digital compliance tools, make sure they have automated reminders for inspections, licensing and renewals. Prepare your Section 8 eviction response templates with the legal grounds and supporting documentation checklist. So your flow around this, how's it going to work? Who's going to do it? Who needs upskilling? Where does the training come from? And then how do you then keep on top of that going forward so that there's never a stone left unturned? And then, you know, with your team training, you've got to make sure that they understand how to deal with ombudsman requests and dispute handling. So don't necessarily keep it to one person, because if one person is not there, they're they're unwell, they're on leave, they're taking additional training elsewhere, then you've lost that information resource there and then. So you need to train up all your staff. Everybody should have a working knowledge. And then beginning a rollout of review of active tenancies to update your records and get understanding about your compliance gaps. And certainly from inventory provider point of view, looking at rolling periodic tenancies, making sure that you've got flexible start and end dates so you can react with the tenant and also with the landlord and with the agent so that you can make sure that nothing is missed. Produce guidance for agents. You know, this is around evidence and requirements of Section 8 and eviction so that you can help them understand their role and help them understand what is required so that if there is a knowledge gap within that particular team, you can help bridge that gap. You can help inform and become part and parcel of their wider network of information. And then you've got your formalisation of your inspection services. So, you know, look at your new risk categories around pets, HMOs and damp. And also have a clear mid-tenancy framework in regards to follow-up. You know, when do you flag an issue? When do you follow that up? How do you follow up? Do you flag that up within the actions, within your reports? Or is it verbal? How are you going to manage that? And how are you going to make sure that going forward, it's dealt with? So these are all deliverables by day 90. So fully updated inspection templates, documented pre, mid and post-tenancy workflows, internal policy and rent handling, discrimination policies, GDPR and licensing, making sure your communications are sent to landlords and staff. Because sometimes I see that staff will know about it, but landlords won't, and vice versa. Get your team prepared for digital first documentation so that you're already aware of what's coming down the line, how you're going to manage it and how you're going to digitize it, and make sure that includes your compliance inspections. And then look at your partner relationships. So those are between your agents and inventory clerks for formalized midterm compliance. So make sure that everybody knows who's delivering what, how they're going to deliver it and when they're going to deliver it and to what standard, and that you're all in agreement, because then that creates a consistency that you all need. So just a final message, you know, a lot of people have got anxiety around this process, but what you need to do is push that from anxiety into action. So enforcement is real and it's rising, it's coming, so let's embrace it. And for me, it's not about just being legal, it's strategic. So we can make it work to our advantage as an industry, as a landlord, as an agent, as a provider. You do have the tools in the industry. You have inventory base, you have the CRMs, Repit, MRI, you have the depository, you have TDS. You just need the workflow. You just got to make sure that everything fits one into the other snugly, a bit like a jigsaw. Yeah, everything has its place to make sure that you get that overall picture. So if you do that, your consequence is limited, your compliance is heightened, and your control is absolute. And that's exactly where you want to be as a business. So with that in mind, bearing in mind I'm bang on 29 minutes past 1. If you do have any questions, do feel free to ask me. If we haven't got any more time, then be happy to take them away and come back to you at a later stage.
Yeah, I think we do have quite a few questions in here, and I think probably the best thing to do is for if you get in contact. I mean, you can either send over the questions to us at events@propertymark.co.uk, and we can send them over to Sean. Some of them are quite detailed and in depth, so I think that probably be the best thing to do.
Yep.
So yeah, if you do have any questions as well, just email them over to us and we'll get those answered.
Lovely.
So yeah, I just want to say thank you to everybody who has joined us today, and also thank you to you, Sean. It's been brilliant. There's a lot of people messaging in now saying it's been really useful, so that's good.
That's great.
And we will see you all soon, and I hope you have a lovely rest of your day.
Lovely. Thank you, everybody. Thank you.
Thank you. Take care.
Bye.